Hey everyone, and welcome to another Rock Your Brand live stream. It's been a while, but I'm really excited for today's stream. We're going to be talking about all things trademarking. It's a topic that I get asked about a lot, and I have some surface level knowledge, having gone through the process myself, and hopefully we're going to have people joining the stream, but if you're watching this on the recording, thank you for taking the time to come and improve your knowledge on trademarking. So I just want to make sure that everything is going okay, do some sort of housework stuff, but everything seems to be fine. I'm just checking to see if anyone is in the chat. I can't see anyone. Well, it looks like we've got viewers, so we have 6 people have joined straight away, so that's awesome. So there we go, we've got some people in. So we've got Lee's, we've got Kaz, so that's awesome. I know it's all working. We'll always have this bit of a rigmarole at the start of a live stream, make sure all the tech's working, make sure that we're all good. I can see Peter as well from Trademark Wizard, so Peter works alongside Oliver, who we'll be speaking to shortly. So Peter will kind of be keeping an eye on the live chat and potentially answering some questions in the live chat, and I'll be keeping an eye on that as well. I've got it in front of me on my phone. So without further ado, I'm going to jump over and hopefully we will see Oliver. There he is. Welcome, Oliver. Thanks for coming along. Do you want to just give a very brief sort of overview of what Trademark Wizards is and what you do at Trademark Wizards?
Yeah, thank you. First of all, thank you very much, Cole, for having me on your show. Absolute pleasure, and I've been looking forward to it for as long as
Happy
you
to have
promised me
you.
that I'd get the opportunity. So I really appreciate you. To everyone, my name's Oliver Oguz, and I'm the managing director of Trademark Wizard. I'm a chartered trademark attorney, and our firm basically, in a nutshell, protects brands for individuals and businesses. So we search for trademarks, we apply for trademarks, we prosecute trademark applications through to registration globally, and we deal with enforcement and defense.
Yeah, that's that's the thing as well. It's like registering, but you also have the defense side, and we'll talk about defending trademarks and stuff later on. So what I'm going to do is I'll just we've got a series of questions. We have had a couple of questions come in from the audience and stuff, but we'll go through my questions first because obviously I'm important too. So we'll just get rid of socials there and bring up question 1. So this is a question which I have kind of tackled to the best of my ability in a video on my channel, but there's always this thing between copyright and trademark and what's the difference. So it'd be great to kind of hear from you, a professional in this field, how you would kind of differentiate between copyright and trademarks. If you could kind of tell us about that, that'd be great.
Yeah, that's a good question, Cole. Very important. But I think before I answer that, I think first you have to take a step back and understand where copyrights and trademarks sit in the whole intellectual property umbrella.
Sure.
So, I mean, what you're essentially talking about protecting is intellectual property rights, and that relates to any intangible property or creation that's created by the brain. And those rights are separated into copyrights, trademarks, patents, designs. You've even got domain names, confidential information. But in terms of copyrights and trademarks, copyright protects you for your literary, artistic, dramatic, and musical work, as well as sound recordings and broadcasting rights, as well as typographical arrangements of stuff.
Mhm.
of work, basically. Whereas the trademark is actually it protects brands. I mean, it protects any sign that distinguishes the goods or services from one undertaking or trader from those of another. So I guess, if you will, it's an indication of origin. And obviously, with copyright and trademark, the test for infringement is also different. Um, you know, separate topic altogether, different rabbit hole to go down. But on a general level, I hope that's answered the question.
So the next question then, Oliver, is what's the process for registering a trademark, and how long does that process typically?
So, I mean, in terms of the process for registering a trademark, before you even start the process, you have to make sure you do your due diligence and do your searches and get the advice and get the correct strategy in place. And then, in terms of the process, you prepare your application, you file the application, and actually, it depends on the territory that you're applying for the trademark in. I mean, let's just assume it's the UK for the moment. And usually in the UK, I guess and this is if you're lucky, Cole, it could take 4 months from start to finish. Actually, if you're lucky, it will take 3.5 months, but I just usually say four to clients, because if you say 3.5, they're on the phone to you on the day. But in 4 months, you should get that certificate through the door. So you apply for the trademark. If there's no problems, you get the examination report, which should be all clear within a month. The opposition period, or the publication period, or the advertisement period is 2 months, which is extendable by a month. But all in all, if you've chosen a distinctive brand that is not confusingly similar with someone else's, and you keep your fingers and toes crossed, 4 months, and you should be good.
I think thinking about, because I just want to say as well quickly, and we'll discuss this in a second, is that I've been through the trademarking process with Oliver and his team, and mine's some of mine's went through in that time period, and we know that, and we'll discuss this, one of mine's took a little bit longer to get through that process. So that kind of leads us into question three, and that's actually maybe it's the next question up, but this question here, actually, how can you determine if so I have something I want to get trademarked, how can I tell if it's already been registered by someone else?
I think before you even, I mean, if you're right at the beginning of the branding stage, I think before you even think about register, who's on the register, etc. I think you should just the most, and it sounds so basic, but it's just do a Google search to see if someone is using that mark, because not everyone has a trademark, but someone might be using it. And even if they don't have a trademark, it doesn't mean that you're not going to get attacked, because they might have unregistered earlier user rights that can be enforced against you and your trademark application. So the Google search is number one. If there's nothing on Google, then you can go to the trademark registry. Again, depending on the jurisdiction that's key to you, but we'll assume it's the UK. So you go to the UK Intellectual Property Office. They've got an amazing search facility on there. Really, it's incredible. So you can search for not just identical marks, but you can also search for similar marks. Well, you can search for similar marks, and they will bring up. Um, they have an algorithm basically that will kind of spit out, if you will, marks that are visually and phonetically similar to your chosen trademarks. Make sure you choose the correct categories that you're that you're looking to do business in. So when you protect a trademark, you have to protect it for different categories of goods and services, and they're grouped into classes. But even if you do find the class that's sort of bang on to what you're doing, let's say, for example, a restaurant, which would be class 43, for example, I think you should also start searching food products and maybe drink products as well, because obviously, those products sometimes are complementary or related to the actual service. So you should really, I mean, the basic searches are key. And then if your gut's telling you that something's not right, or you have the budget to actually get professional advice, then do it. Um, you can do it yourself, but it's always good to have a friendly trademark lawyer that you can ask if there's going to be a problem.
That's the thing for a lot of especially in my field, the logo design. There's that thing of we're not all working with clients who have big budgets, and we don't all have lawyers on
Yeah,
hand to do that kind of stuff. And so there's always that I suppose a fear with logo designers of I've been through. I mean, obviously, if it's a name's much easier to search.
sure.
Type it in and see if it comes up. With logos, it's a little bit more complex, but not super complex. I know that I've got a video on my channel using the WIPO, the World Intellectual Property Office website, but that's not. I've found that it like some stuff will show on the UK IP site, but does not show on WIPO. So it shows that it's not infallible. But I always say to other designers who ask, it's like, well, just do as much as you can, and if it's not coming up straight away,
Yeah,
then you're probably going to be, okay, I can't, it's that, not financial advice kind of thing. This is not
absolutely.
trademarking advice. You still have to, it just should give you more confidence that the logo concept that you're creating has a better chance of going through the trademarking process. I mean, it's a weird thing in that when I started as creating logos, I didn't even think about trademark that my clients would be trademarking things. But when you start to bring trademarking into your process as a designer, it gives you way more worries. You start to worry about your concept more. But actually, I feel it makes you a better designer because you're trying to create something that's more different and less obvious. And if you do that, then the chances are that you're going to create something which is unique and is going to be. Now you talked about registering in the right category and the right classification. Quick question, which isn't actually on here, is that let's say I find a logo which is similar, not exactly the same, but it's similar, and it's in a category and a classification that's completely different to my client who be in a very different category. What are the chances of my design still being rejected, even though it's in a completely different category to the one which is?
I think the key thing here is the phrase completely different, because it's very subjective, isn't it? I mean, I think first of all, you probably have to look at how close the marks are to each other. I mean, let's say we're not talking about the words, we're talking about the actual design. Okay. And let's say, the designers, have not taken any inspiration from said person who's starting to attack them. But, just out of coincidence, there are some similarities. So if the marks are similar to a degree, and there's all we can have some wordplay here. It can be to a low degree, a medium degree, a high degree, but they're not identical, but there are some similarities. Then you would look at the goods and the services, and what you're saying is if they're in a different category. So I think we'll go back to the restaurant example. So let's say, the earlier trademark was registered for restaurants, but then, Cole, you came up with this brilliant, unique, distinctive design, from a blank canvas. And let's say your client had let's say your client was selling, let's say chili sauce. Don't ask me why that flew into my head. Let's say chili sauce, right? So then you would look at whether there would be a likelihood of confusion. And then you would have to look at, again, you go back to the whole, um, are the goods and services complementary? Are they produced by the same people? And then I think you could look at, let's say, Nando's, for example. You can go into Nando's, and you can order some chicken and sit down and do whatever you do with the chicken. But then you can also buy some chili sauce from there as well, because they have their own sauces. So really and truly, then you would be looking at whether there's a likelihood of confusion. But that's only if there is some relationship between the classes. So then we're talking about, is it different or completely different?
Yeah, so if I was creating a logo for my client and they were a car manufacturer and the registered logo was for a restaurant, it's unlikely that someone's going to be confused between buying a car and buying food from a restaurant.
Yes, but hold on for a so okay, go on. Yeah, yeah. So that means there would be no confusion. Okay, so you could park that argument for one side. But then, if and we're going back to the point, completely different. Okay, so completely different. Let's say the technical term for that in Anaraki trademark language is dissimilar. Okay, so let's say the goods and services are dissimilar. If the other party, the person with the earlier trademark, was to have a claim, what would have to happen is that they would have to have a reputation first. Okay, and if they have a reputation, then even if the goods and services are dissimilar, they may be able to prove, you don't need confusion, but they may be able to show that what you're doing potentially is taking unfair advantage of their reputation. And obviously, if you provide a service or some products which are of inferior quality or substandard, then that could tarnish their brand, and that could be detrimental to the distinctive
That's
character.
that's really interesting because that's cleared a lot for me because there's a lot of I know that I've spoken to people and stuff and we get as far as it's a common sense thing as long as there's no confusion, as long as
Yeah,
someone doesn't think they're buying that. But what you've just said there about this could be a very popular restaurant, high end for high quality food, and yes, my
no, no,
my client's making a car, but they could, as you say, be leveraging some reputations for high quality and using that leverage. But if they make cars which end up being absolutely crap, that could also affect the restaurant because they're like, oh, there's this, the logos and stuff are there's a similarity there. The categories and services are dissimilar, to use your Anaraki word. But yeah, so that does make a lot of it is still common sense. It almost at its roots feels common sense in terms of how that is. But I'd imagine, and we'll kind of go into this next question here. I think this is the question. Yeah, so the next question is, what happens if someone opposes or objects to my trademark registration application? And that's where I kind of wanted to kind of come in and say, this happened to me. And, and it was, for me, when, I worked with yourselves to put my logos through, and we all thought, yeah, this should be fine. I put through Pixels Inc. Name and logo, and also Rock Your Brand, and the interesting thing with the Rock Your Brand one was I had the name, I wanted to trademark the name, and I also wanted to trademark the logo. But there was it was actually the trademark people who said that the I think it was the logo element wasn't I can't remember what the technical term was, but essentially they said you can't have them both trademarked in series, to like together. And so I just like, you know what? I'm thinking about changing the logo anyway, so let's just secure the name. So I just went ahead with that, and that was fine. But it was the Pixels Inc. part where I got Pixels Inc. the name, and I got Pixels Inc. the logo type. But then there was an objection came in and some of the people watching who know my business Pixels Inc. know that I use a P and an I inside a circle, and I thought, well, I used that, so let's try and get that as a mark as well. And that was so going through this sort of process that you said was 3.5 to 4 months. Everything looked like it was going great. That's been approved, and then I get an email from yourself saying, oh, someone's raised an objection. And yeah, for me it was quite not. I don't know if I was like scary or fearful, but it was seeing the letter, and it was like from a big lawyer firm, it had London, New York, Paris, and I'm like, oh my goodness, this isn't like a local courts thing. This is a big thing. And all I'll say is, at the end of the day, it was all resolved. And I think part of it was resolved through to what you've already mentioned, and that's reputation, in that I'd been using the PI longer than their client. And the interesting thing for me was they hadn't even trademarked it. They put a trademark thing in a month after I started my process. And so I think what you interested me as well was that you said there are lawyers out there that just look for new registrations going through and look for like maybe the slimmest of things in order to, they might just be trying to get money for services that they're trying to protect their client. But I mean, in the end, my trademark went through, and we came to an agreement that I wouldn't do anything. I think they were software as a service or something, and I wasn't going to touch on that anyway. So we came to an agreement that they wouldn't get involved in my area, I wouldn't get involved in their area, and it all went through. But there was the interesting part as well where because I was kind of worried about it, I was like, well, I don't care about it. Let them just have it. And then you were like, see, now if you give this up, they could then come after you because you've been using it for years and say, you've been using our, intellectual property. We want damages for that. So it's like, oh, I have to go through this process. So it was really, really interesting to go through that. And as I was going through, I was going, this is actually, for me as a content creator, this is really good because there's nothing worse than going, yeah, I trademarked my logos. It all went fine. It was great. Trademark wizards were brilliant. They helped me do this. But actually, this kind of going wrong was a good experience to see, well, what happens when someone does oppose it? What's involved. And so, this is, I'll let you kind of talk about the process that you help clients with. But all I want to say is that this is an example of, yes, you can register your trademark yourself. You can go through your local, your country's IP, website, the government website or whatever it is, and do it yourself, and it'll be cheaper. But this is where I would like you to talk about, what happens if it opposes, and not to give figures on what the like legal fees and that would be, but, just talk about the fact that if you do this on your own, you would have to, potentially hire lawyers and stuff. So I'll now mute myself and let you answer the question, what happens if someone opposes or objects to my trademark right?
So, Cole, if someone opposes or objects to your trademark application, and let's use the word challenge, okay, or let's say raises a concern, okay. Now, if someone raises a concern to your trademark application, I think before you decide what to do, I think you should always look at what that concern is, because in the end, you might have a brand that's the same as someone else's brand. They might be let's say, a software company, and you might sell dog food, and there's never going to be any confusion in the marketplace. You both know that, but maybe, they just need um, that bit of comfort and that assurance that you're never ever, you're just going to sell your dog food, and you're never going to start, inventing software and apps and stuff like that. So they might just say, can you please promise, Cole, that you're never going to start making apps? In which case, you just say, no problem, mate. See you later. But then it might be a bit more than that. Maybe they want you to delete things from your scope of protection. And then if they're asking you to delete stuff, then maybe you have to consider whether what they're asking you to delete is reasonable or unreasonable, whether it's gonna be detrimental to maybe to the value of your brand, but also to your enforcement rights as a whole. But then, or they might say, look, you know, there's a problem here, okay, but let's both agree that we're never going to tread on each other's toes, and then you can negotiate a coexistence agreement where you just agree to live peacefully side by side with each other, and that's fine as well. But those kinds of agreements sometimes, they need a bit of toing and froing from lawyers. So that sort of stuff can be kind of dealt with. I mean, it's a bit tedious, it's a bit frustrating. Sometimes you might have to put your hand in your pocket, and it might cost you a bit more money than you budgeted for the application. But at the end of the day, you're drawing some clear blue water between you and a potential attacker, someone that might sue you. So it's worth getting an agreement in place. But then it could be that it's not just someone that's opposing your application. They might be not opposing your application, but also challenging the use of the trademark. And this is you're in cease and desist territory. Someone's telling you to stop using the name, and if you don't stop using the name, then the bottom line is they'll take you to court for trademark infringement. And then the remedies that are available to them are, number one, the injunction. They can stop you using the trademark. Number two, they can get everything with the trademark delivered to their office, their lawyer's office, or it can be destroyed, or transferred. We're talking about domain names, social media handles, the whole shebang, basically. Also, they can get damages or an account of profits, and that can be up to £500,000, £500,000. And that is a bitter pill to swallow. And then on top of that, they could ask for their legal fees as well. And if it's in the intellectual property enterprise court, from our experience and from the guidelines anyway, it could be up to £50,000. So in terms of what happens if someone opposes your trademark, it depends on whether it's just don't sell dog food and I won't sell, or don't sell software, just sign that bit of paper. And it can range from that to you're getting, I'm going to bounce you into a courtroom in 14 days if you don't stop using the brand on what you're using it on. So it is, it's not something that the client, well, that people want to hear, but it does depend on the nature of the challenge, if you will.
Yeah, there is that thing, it's like, it depends. We have that
Yeah.
phrase in a lot of places. I suppose it was just kind of like, because the letters that you were sharing with me that they'd sent, or they've sent this, what do you think, and it was just some of the language and stuff was like quite
Sure.
frightening to me, but you were like, yeah, I know this. I know these people. We deal with them a lot because they represent. We're in this sort of a similar industry. That so for you, it was just another day at the office. And what I appreciated was you kind of putting my ease and saying that it'll be fine. We'll sit down with them. There's have you got evidence of this? And my thinking is for those people who decide I'm going to save a few quid and I'm going to go through, let's use UK again, I'm going to go through the UK government thing, I'm going to submit my name and my logo, and I'm going to go through that, and then they receive a letter from a lawyer firm saying we think you're infringing on something, and you're like, so what does that person do? Do they have to go on Google and go, well, what do I do? I have to hire a lawyer to find something. So I know obviously that when I signed up for your service that there was that the legal fees side of it. If anything happens, we will deal with that on your behalf. And so there is obviously there's a fee for that. And sometimes it will need to be used and sometimes it won't. But I suppose it's like an insurance policy, isn't it? It's like you take it out in the hopes that you don't need it, but if you do need it, then it's probably going to save you quite a lot of money because you need someone who knows what they're doing in order to deal with that. And you might have someone who's not like me at all, and they're super confident and they want to represent themselves in court. I don't know, and they're like, yeah, I'm not paying for no lawyer. I'm going to do this. But I think for most people, they want that kind of peace of mind that if something does go a little bit skew with, shall we say, that there's someone there to kind of deal with that. And even if it's like, yeah, this they're just chancing their luck, this is not going to go anywhere, don't you worry about this, we'll go have a word with them. Look, come on guys, it's nothing like it, you're just you're just trying to put the pressure on someone to get something. And I kind of felt that way with mine when I started to look at the detail and go, they don't have the trademark, they don't really use PI. It's like I've just kind of, because I've registered it, it's kind of our client's got something similar to that somewhere, I'm sure. So it was really, really interesting. And I would just say that for me, this is not, I'm not telling other people to do it, but for me, I was so thankful that, because I was going to do my trademark registering myself, and I'm glad that I'd mentioned it to Ian from Logo Geek, and he said, well, I've been working with the Trademark Wizards, and then I started having a look, and then we got speaking and stuff, and it was like, yeah, actually, you know what, once you started talking about all the categories and the classifications, and that's another thing, again, it's not in the question here, I don't think it's in any of the questions, is that when I was going to register, I was just going to register in the category and the very specific classifications of the stuff that I do or did then, not thinking to the future, where you were like, well, is there any chance that you might start doing this and this and this? Well, we need to, we should get that registered so that you've got that covered as well. So there's all that kind of stuff that your expertise will bring to someone who's just like maybe read a blog post on how to trademark. Here's how to trademark, and I'm sure you've got content on that, but it's a very different thing once you get into the tiny details of it. So yeah, that was kind of me, that was my story, but the rest of these will be questions that you can just answer. So what are the benefits? Why should someone trademark? Why can't they just start their business, get a logo, get a name, and just trade? What's the benefit to this protection?
I think the first thing, Cole, in terms of the benefit, is that trademarks are not just swords, that are used to attack people with. They're also shields as well. Okay, and I think having a trademark registration for your business, it serves as a defense if you're sued for trademark infringement. So if someone tries to say you're infringing on their trademark, and you just pull your trademark registration out your back pocket, then that's your defense right there. So that's the first thing. You're protecting yourself. But then in terms of the other benefits to it is that you can stop people using identical and similar trademarks for identical and similar goods and services if you think there's going to be some confusion in the marketplace, and that's important. It also serves to, I guess, as one element of, well, actually it serves to try and maximize the potential of the value of your brand. When someone, I mean, obviously you are the most important part of your business as the CEO of the organization, but when someone buys your company, they're buying your brand, and you know, they want that trademark registration certificate. I mean, there's so many benefits of it. I mean, if you go and seek investment for your business from someone, and you don't have a trademark registration, then well, how are they gonna give you money? Because you don't have the brand protected, and you can also, how do they know their money is not just going to be pumped into lawyers for I say this respectfully, but when you start pumping money in the lawyers as an investor, that's money going down the drain, if you will. So there's so many things. There's so many benefits of it. I can start doing it till the cows come home. But if you don't have one, then what are you going to do if you build up this brand and you build up this really good reputation, you generate all of this goodwill, and you don't protect your trademark, and then someone else wants to start a business and they see yours, and they think, you know what, I'm going to do that, and I'm going to mimic it, I'm going to copy it, I'm going to produce a carbon copy of that guy's business, including using the same name as him. Forget about the logo, they're going to use the same name as you. And then you Google your own business, and there's two of you now on the register. And that guy, let's go back to the restaurant example. And if you have two restaurants with the same name, let's say one of them's a high-end restaurant in, let's use Mayfair, for example, and they're charging £50 a head if you're lucky for a starter. And then you've got this other outfit that's using the same name. And let's just say that let's say they had a rat infestation. People might think that it sounds extreme, but these are things that can happen, and they got shut down by the council. People are going to be quick to go online and think, there's a franchise here. These two people are connected. You could damage your reputation, and in order for you to enforce your trademark, well, you don't have one to enforce. So
yeah,
so
that's it, isn't it? You've
yeah.
nothing to do. So would you suggest then, as part of again, I'm kind of adding in questions, I'm trying not to, but questions are kind of sparking. Like you say, you could spend years building that reputation, and I have a similar kind of experience with the Pixels Inc. thing, which was kind of what sparked me to do the registration. Was someone else did start a graphic design business called Pixels Inc., but they were in the US. And obviously, I'm in the UK, but there was just that thing of, well, even, what if they decided to grow a large agency and open up in the UK, then I couldn't really do anything. They eventually closed anyway, and I managed to get the domain name, because they managed to sneakily get a domain name of Pixels Inc. And I'd forgotten all about that domain, but I've got that now. But would you suggest to someone who's starting a business that trademarking should be a real part of their business plan in the early days? If you're serious about a business, it should be included as part of the, so for example, someone comes, they're starting a business, they're needing a logo, so they come to me, and I now have conversations with clients saying, will you be trademarking? I would recommend it, I don't do it for you, but then that's when you make recommendations in that. And what I've found is that in the UK, most people haven't even considered it, but my clients in the US, it's very much one of the first things that they are going to do. And I don't know if it's because the US is more litigious, and we hear that they're always suing one another and things like that. And in the UK, it's kind of all stiff upper lip and I won't do wrong by you, but we know they do. There's just as much going on here. It's just maybe not as many people, kind of being taken to court and things. But I do find that interesting, and I haven't seen it change. I've not seen, more people say in the UK, I'm gonna. It's taking me to have a little discussion about exactly what you've said there. It's using it as a shield rather than having a trademark to go after people and say, don't you use my trademark. It's that protection of. There's nothing worse, because as you said as well, is they will take. They don't just take all your social that you've built up, all of that stuff. They will get the domains. They will, and you're just losing everything. So, I think it's something that people need to take seriously. And I think as logo designers, it's something that should be part of our process, that we at least discuss with the client to make them aware of the benefits of trademarking and why they should potentially, once everything's been signed off, that's maybe a next step that they should do is speak to someone about going through that process. Like I've said, it's easy to kind of check if a name's taken and where it is. The logo's a little bit different now, but I know that you've got pretty good system that you guys use for checking logos and bringing up any potentially similar marks that could kind of go on there. I think another thing as well is that, kind of to touch on it, is that for me, I feel that it brings a bit of trust to the brand from a buyer's perspective. Someone who's going to buy from the brand, if it's registered as a trademark. I mean, it doesn't. You could register a trademark. It doesn't mean that you're not. You could be a scam artist and still register a trademark. But I just think if you're going to go through all of that effort, 3.5, 4 months going through all of that stuff, that you're probably a very serious business. And, so I think there's a level of having that little R brings a level of trust to your brand as well, which, as you said, brings value. If you're going to maybe look to sell your business further down the line, being able to say, yeah, I've got all the trademarks for this as well. I don't know how much that would add on to the value of the business overall, but I'm sure it's not insignificant, and it will make a big difference. So the next question is, how long exactly does a trademark registration last for? Is it infinite until you pop your clogs, or do you need to renew it
In terms of how long does a trademark registration last, as long as you renew it, it can last forever. Okay, so in the UK, when you file a trademark, from the filing date, from the date of filing, that trademark will expire, assuming it gets registered. It will expire 10 years from that, from that date. Okay, I guess your lawyers, your trademark attorneys, whoever's dealing with your deadline management, they'll send you a renewal reminder in good time before that date. If you do, I shouldn't even be saying this, but let's just say you do miss that deadline. Okay, let's just sing the devil's name. If that deadline was missed in the UK, there is a late renewal mechanism. You do have to pay a penalty for doing it, but if you miss the deadline, you can kind of get a squeeze, and you're able to renew the trademark, and that's a 6-month extension. If you miss that 6-month squeeze, then there's something. Well, you can actually still revive the trademark registration, but you're going to have some good excuses there. They might even ask you to show them the dead body as to why as to why you've missed the the extended period. But it's usually 10 years, okay? But what you should a good take home here is that when you've registered your trademark in the UK, your trademark can be cancelled if it hasn't been used in relation to all of your products and services within a 5-year period after registration. So even though you can renew it 10 years later, someone can still come along and cancel it after 5 years. So what you should be what you should be looking at is making sure that if you do have a broad trademark application or registration in relation to not just your core service offerings but complementary ones as well, make sure you're using the trademark for those services or those goods. And if you're, let's say you're a fashion brand and you sell clothes, but you're registered for jewelry and watches and bags, if you're not going to sell those goods yourself, maybe try and license your brand into those areas. And let's say you're a graphic designer, okay, but then obviously you're going to protect yourself for digital marketing services, things that are maybe video production and stuff like that, because obviously these services are complementary and related. So with graphic designers, for example, or branding consultants, sometimes people might come to you and say, well, I'm just saying, for example, Cole, I'm going to use you as an example. They might come to you and say, look, I want you to design a brand for me, but also I want a website developed, I want digital marketing and all of this stuff. And I don't know what you would do, but some people might say, well, I'll do your logo design, but that person, I'll introduce you to that person for the digital marketing, that person, whatever. But if you want to avoid the revocation of the trademark, sometimes you can just take the project under your own umbrella and obviously get the freelancers in and do it. And I don't know how it works in your industry.
Yeah, that's pretty much, that's kind of, yeah, it's sort of how I do it. I'll basically, I'm the point of contact for invoicing for the client, and I'll subcontract, the web company, the video guy. And so, yes, it's all, so that's technically under Pixels Inc. because the invoicing
that saves
to the
your
client.
trademark from cancellation, basically, for those other goods. Whereas if
so it's kind of, it's
sorry,
similar in terms of the registration side. It's similar to sort of website domain names. It's just as long as you renew it, you've got it. But yeah, so 10 years. But that's a good. It's a good thing about the 5 years. It's like, because you go, I've got it registered for 10 years, I'm fine. But like you say, if after 5 years, someone who's interested maybe in getting a trademark similar, but they're like, we can't use it because they've been doing that. But actually, I've not seen them do anything in that space. So maybe we could kind of go after that and get that and pull that. So, because I was thinking it'd be very easy, like when you do the register your trademark, you just go, I'm just going to tick all of the boxes to make sure that nobody can do anything under my name in any of these things. But like you just said there, you have to actually be doing that stuff in order, because it's just, otherwise it's like, it's similar to someone buying a website domain name, never using it, they're just squatting on it hopefully that someone might want to buy it. I mean, I don't know if that's the case. I don't know if people have done that in the past. They will register a trademark and then someone will come and say, hey, we want to do that. Can you do that actually? Can you, so if you're halfway through a trademark registration, is it just a process of reassigning who the owner is of a trademark? Do you just pass it across?
You mean if you want to sell the trademark?
Yeah, so let's say Pixels Inc. and I'm like, I'm done now. Someone comes to me and says, oh, I hear that you're giving up. We'd like to continue as Pixels Inc. Or is that a case of, or let's say I want to continue as graphic design, but I don't want it to be called Pixels Inc. anymore. Can I sell it? Probably not. The more I talk about it, I'm thinking, no, that doesn't make sense.
no, no, it does win. It makes complete sense, actually. Got complete sense. So, I mean, that's the benefit of registering your trademark in classes that are related and complementary, because obviously, if you're not exploiting the brand in those related or complementary classes, someone might come along and say, and we're talking about transactions here. Someone might come along and say, "Oh, Cole, um, I'd like to either use your brand for something related, or I'd just like to buy your trademark for those classes." So you could either give them a license and get a royalty fee, or you could just hive off that class and say, "Here, you can sell the class to them by virtue of an assignment." But then if you didn't register your trademark in those classes, then you don't have that option. And it's only 50 quid for each additional class. So it's one of those things where you really it's a benefit of registering the trademark. I mean,
Yeah,
you would
that
probably,
makes sense.
yeah,
Being able to license your IP,
yeah,
because if you're building up we talked about building reputations, and yeah, someone who wants to start doing something, they're like, we would love to do something, and they're actually going to get a boost from the reputation of the trademark holder, who's then
yeah,
like, okay, so I suppose it's a bit like anyone who wants to make Star Wars toys, for example. They have to go to Lucasfilm and say, we want to make a Star Wars toy, and Lucasfilm go, okay, we will grant you license on our IP, on our trademark in order to do that. And they've probably, I don't know what kind of money goes out there, but it's probably a lot of money. Not that I'm ever going to get get to that point, but you never know what that's going. So that, yeah, so that's cool that we now know how long that's going to take. So this question here is slightly different to the checking to see if it's if someone already has it. This question here is there a way to check if what I want to register is likely to be opposed or rejected, so I don't waste any fees? So you kind of go through the process and like, oh no, you can't have that, and you're like, well, I've already paid for it, but you don't get your money back. It's like, that's it, it's gone. Is there, I know that at Trademark Wizards, you've got, you can do checks and stuff. So is that the benefit of using someone like
it goes back to making sure you do due diligence and doing a search, because there are two reasons why your trademark's not going to go through. Number one is that it could be descriptive of the goods and services that you're providing, and therefore it would be unfair for the government to give you, that monopoly over the brand. But then your attorney would give you the advice and tell you how, tell you what the chances of receiving that sort of objection are. Whether the trademark is um, non-distinctive or whether it's descriptive. It could describe the nature, the characteristics, a geographical location or something like that. So, or it could be a word that's customary in the trade or generic. So that's one, and that's possible. And a lot of people come up with brands that are, there's a spectrum, isn't there? So there's a spectrum of distinctiveness, and on this side, you have a completely unique name. I don't less Esso or Exxon or whatever it is, and then on this side, you've got completely descriptive names like graphic design company, for example. So it does what it says on the tin. So it depends on and then in the middle, you have elusive names. You don't know what side of the spectrum, of distinctiveness or descriptiveness, your mark's going to fall into. And so that's what your trademark attorney will tell you, and tell you the level of risk. And then the second thing is that in terms of wasting your money is the search for earlier trademarks. So the second reason why your trademark can be attacked, or the use of your brand can be attacked, is whether there's an earlier trademark that conflicts with yours. And sometimes you can go onto the IPO register and have a look and whatever it is, but sometimes you don't know, because the test is, are the trademarks similar? And it sounds subjective, but there is a science to it, where trademark lawyers spend years in school just to look at, um, to tell whether two things are similar or
And
not. And I
that's,
think,
yeah, I suppose that's kind of what I was getting at, is
yeah,
that that's where if you want to kind of have a much better chance, it's in a weird way, in a much better chance of not wasting your money, is to actually spend money with someone that can do, like you said, have years of knowing and being able to look at something. And so you're actually, your money's being well spent, because you're getting the confidence that this is going to go through. Whereas if you do it yourself and you've not done the right searches, and you might not have done any searches at all, you're just like, I want to register this, and you put it through, and it doesn't go through. Then yeah, I'm trying not to make, what I'm trying to do is, I'm trying not to make this live stream a use Trademark Wizard stream. I'm trying to just
no, no, no,
be
no,
on
no,
here
don't.
and get
I
you
mean,
to sort of, so when I say use,
absolutely not.
pay money to use
Yeah,
it, it could be anyone. It could
yeah.
be anyone that that you find online who's a trademark attorney, a trademark lawyer. I just know that there has been benefits. I'm seeing that there's a bit of action going on in the YouTube chat, and I'm just going to leave it, and I'm going to review it at the end. I can see Peter's been replying, so I know that Peter's kind of not leaving people hanging. So we'll have a little look at that once we get through.
I would say, Cole, just obviously on the whole trademark wizards advert, this is not about that. This is about just giving, informing people about the procedure and what to look out for and stuff like that. And in terms of choosing a firm of trademark attorneys or having a lawyer, I think it's just helpful, as a logo designer or whoever it is, just to have a sort of a friendly trademark owner a friendly trademark attorney on the other side of the phone that you can use as a sounding board. Someone that, sometimes you have a gut feeling and you just want to have someone to say, look, what do you think? Is it similar? Is it not? Is it confused? Pick up the phone. And sometimes, because we do this every day, it's second nature to us. We don't have to go through the analysis. We just spit it out in our head. And there are so many good firms out there, and there's so many good trademark attorneys out there. And, I would just say that, when you're looking for someone, make sure that they're regulated, make sure they have insurance, and yeah, just make sure that, I guess, make sure that there are certain questions that you can just ask someone that they can give you a friendly answer to. And I think that when designers are building relationships with trademark attorneys, sometimes as a designer you use other things, you have to get inspiration from somewhere, and depending on how you deal with your design brief with your clients, sometimes you would say, some people would say, oh, what brands do you like in the marketplace or whatever. And sometimes they might say, look, I want to get a bit close to that one, because I like that one, but I don't want to stay so close to it that obviously I'm infringing. And these are real questions that need to be answered, and these are what trademark attorneys would do, or barristers or whatever. So sometimes it's just good to have a nice friendly trademark lawyer that you can sort of call up on the other end of the
Yeah,
phone, send a cheeky
totally
email
agree.
to,
I
whatever.
totally agree, because there is a lot of, I know there's, I know a few people, and if they're watching this or whatever, they'll have a little smile in that. It can cause, it might sound silly, but it can cause anxiety and sleepless nights if you've got this logo and you're
Sure.
really happy with
Yeah.
it and it fits the client, and you're just like, I don't know, it might be similar to this, but, and then you go to another designer and go, does this look similar? And they'll maybe either say, well, it does a little bit, or no, I don't think, I think there's enough of a difference there. But just having that, like you say, find someone you can pick up the phone and have them as an expert say, yeah, I think there's enough, dissimilarities there that you probably, you won't have a problem. But that's a good point as well, where I tend to not ask clients anymore, what logos do you like? Because it gives them this sort of a false sense of they're going to get something like that. Um, I'll maybe ask questions like what sort of style do you like, but I very rarely get them to show me, oh, I like the Nike logo and I like the Adidas logo, because then it just sets an expectation. But that's an entirely different conversation. That's a design conversation. So one of the very early questions actually was from Lise, and Lise had asked, I'm in the EU. I'm assuming that you're both in the UK. Is there any big differences? And so the question that I brought up here is, are there any international considerations to keep in mind when registering a trademark? And that could be someone in the UK and out with, or someone like Lise in her country and then out with. What sort of things should we be thinking about when it comes to
I think there's one big take home here. If you're going to remember something from this whole conversation, remember this. So first of all, remember that trademark rights are national rights. Okay, so if you register a UK trademark, you're protected in the UK. If someone registers your trademark in the US, when you go to the US, you're blocked, or they can sue you for infringement. Yep, okay. However, okay, there's something under trademark law called the priority period. It's very important. And what that means is when you file your first trademark application, you're protected globally for 6 months. And that's called the priority period. So let's say you start off with a UK trademark application. As long as you extend protection, let's say into the EU or wherever else it is around the world, within that 6 month period, all of your foreign trademarks will be backdated to your UK filing date. So, sometimes it's difficult because of the internet, customers are borderless now. So but then again, you can't just protect your trademark all around the world as a startup. It
I
doesn't
know I
happen.
couldn't, because it gets a bit pricey.
So you file your UK trademark first of all, get your stake in the ground very quickly, do a search. Like I said, if you're lucky, get some advice. And if you're lucky, within 4 months, your trademark in the UK is going to be registered. And then what you can do is you're still within your priority period. So then you can have a look at situation globally and then plan your international filing project from then on. But I would probably say in terms of international protection, if let's say you're a clothing brand, for example, don't just protect the trademark. Obviously protect it in your home territory, but don't just protect the trademark where you're going to be selling goods into. Okay, let's say you're a clothing brand and you wanted to sell your clothes in the US, very common, and in the EU. Don't just protect it in the US and the EU. You might be producing those goods in China. So you make sure you protect the trademark in China, because that's your country of manufacture. You want to protect yourself against counterfeit goods being produced in that country. And I would also say protect your trademark in places where counterfeiting is rife as well. So those territories, but also have a backup plan just in case you have to move factory. There's been times where we filed trademarks in China because that's where the factory is, but the factory has hijacked the trademark, or the trademark hasn't been able to go through in that country, or the client's been sued for infringement in China for producing the goods, so they have to move production to another country. So you should always perhaps have a plan B. I'm just saying, let's say textiles, for example. I'm just going to say Turkey because my dad's Turkish, right? It doesn't have to be Turkey, right? But sometimes a lot of textiles clothing is produced in Turkey or Vietnam or whatever it is. But make sure you have a trademark there just in case you have to shift production.
Yeah.
I think
So is so how you're talking about, you've got that 6 month priority. Is that a law that's in all countries where you can register a trademark? Is it kind of is it something which is agreed upon? So in the US, if I register a trademark, do they also have that 6 month? If Lee's registers a trademark in, I forget where you are, Lee's. I think it might be the Netherlands. Do they have the 6 month priority? Is it it's a common thing across the
But,
board?
yeah, I mean, these are any country that signs up to the treaty, where um, there are, where there's an agreement, that there's reciprocal treatment between countries, um, I think it's the Paris Convention. I'm sure it is. I think that's the treaty. But members of the Paris Convention benefit from the priority right, basically. So if one country, it's the principle of, countries and territories treating each other the same, basically.
Yeah, so a lot of the stuff that we are discussing today and the questions that you've already answered will be similar for, if you're
Yeah.
doing a trademark in a different country. The sort of the processes are very similar, across the board. I think that's kind of, because I've got a lot of people all over the world who watch these videos, and so it's like they'll be like, oh, you're both in the UK. Is any of this relevant to
Oh yeah,
me?
yeah.
And it is, it is clearly something which goes that way. So the next question, I'm very aware of the time. I appreciate the time that you've given me
All
here.
right. I could do this all day long, Cole.
I know
You're
you could, and I'm like that when I'm talking about branding and strategy and stuff. I could talk about it all day. I don't want to put that onus onto you as well, just because I could talk all day about it. Can I change or update my trademark registration if my brand evolves or expands over time? Can I just go back in and add an extra thing to it, or is it a new registration from scratch?
I think let's just have a look at the UK as a starting point. So remember, there is the principle of revocation that I mentioned. So if you don't use your trademark as it appears on the register in relation to the goods and services that you're protected for within a 5 year period or for an uninterrupted period of 5 years, the trademark can be cancelled. So um, if you do evolve your brand and change your logo, then you would have to file a new trademark application because you can't amend the trademark on the application or registration once it's been filed. So I would usually say, in terms of designers and stuff like that, make sure that when you do file the trademark with designers that design logos and stuff like that, the trademark attorney is the bridge between the design department and the legal department. But in a small business, there are those departments don't exist, but you still sort of need to have that focus on infringement. And sometimes you need, when you come up with the name, you want to get that name protected, get the name searched, get the name filed, and then what you then do is develop the logo. And once the name has gone through, then you can kind of bet your bottom dollar that the logo is going to go through as well. But then don't file the logo until you're happy with it, because sometimes people file a logo and then all of a sudden there's a few tweaks that need to be made, and then someone has to get it in the neck because someone's got, there's more money that needs to be spent on another application. So in that respect, just make sure that you file the logo that's been signed off. You don't be too hasty with it. And if you do evolve the brand, I mean, if it's a case of just really, really small tweaks that are just not even noticeable, then maybe you can keep your same trademark registration and it will affect it, and it will still be enforceable. But if the changes that you make are material, then you've got to go back to, you've got to file a new application. But as long as the trademark is an original copyright work from your designer, you can kind of, it's going to, it's more likely than not going to go through, and you're not going to get challenged because of the wording, because you've already got the trademark for it anyway.
Yeah, that all makes perfect sense to do that. So I think this is the last question that I've got. Well, the last question, which I have here. I know that there are questions here, and I'll have a quick scan through in case there's anything we can ask. So this question is actually from one of the audience members. This one's from Henry, and it's like a double question. So do we register? And I know that we had a chat earlier, and you now know what a logo lockup is. So you know the term a
Oh yeah,
logo
thank
lockup.
you
So
for
that's
that,
like a
by the
stacked
way.
version of it.
Yeah.
Um, so do we register logo lockups separately? So are they a set? So if I've got a stacked logo and an inline one, are they separate registrations that I have to do? And does one registration include the black and white version? So your logo is generally going to be in a color or some colors, but then you're also going to have, a one color version, so black or white. Is that included? So what's the ins and outs of registering a logo design?
I think the best thing to do is take a quick step back and look at all the elements that are relevant to the brand in itself. So let's use our trademark, for example. Got my business card here, which was designed by Ian from Logo Geek, who you've already
Um,
mentioned.
I will
Um,
just unmute myself there just to say that. So on the stream, you can't really see it, Oliver, but your logo is sitting below your name. Everyone can
oh,
see it on
really?
the
Okay,
stream.
fine.
Yeah,
Yeah.
yeah, yeah. It's sitting there, but it's nice to see your business card as well, though. Yeah. So
Right.
just a shout out to Ian from
Yeah.
Logo Geek, who was the one that introduced me to Oliver and his team. And Ian, it's fairly recently in the scheme of things. I think that Ian redesigned the and created the existing trademark Wizards logo, and that must have been an easy thing for him because he wouldn't have to worry about will this go through a trademark process because like working on that you'd be like, Ian, we can't use that, you're going to have to tweak that because that's probably not going to be trademarkable, we need to make sure that it's trademarkable. But that would have been an easy process to go through that, literally having the ear of the trademark attorney to check on things. So yeah, so great
Ian's a
job,
good
Ian.
egg.
Yeah, so I will I did tell him I would give him a shout out today because we were bringing up the logo.
Yeah.
So I will mute myself again and let you get back to that, taking a step back and looking at the elements that need.
So yes. So if you look at the elements, so going just being quite basic, there are three elements to our brand. So the first element is the words trademark wizards. That has to be protected. Okay. The second element would be our stylized font. Okay. And there's a little tweak in there that does make it a bit distinctive and worthy of protection. The third element is what we call the distinctive device element, which is the badge, the symbol. Okay. And then, so all of those elements should, I mean, it's easy for me to say this but it's all down to budget. Each element should be protected separately. But then what you're saying, Cole, is you're referring to what's known as the composite trademark, which is all elements together. And how do you protect that? So I guess, but remember in the UK, you can apply for two versions of the trademark in the same application, and it doesn't cost any extra money. And that's called a series application. So, the easy answer to the question, if I was trying to sort of dodge it, is that you would just put the stacked version as one version of the trademark, where the device could be at the top, and even the letters, sorry, the words can be stacked as well. Or you could do it sort of in a long way, where the device is on one side and then you've got the words coming across, and they can go in the same application. So and they will be protected together because they're not materially dissimilar from each other. But in some countries, Well, in most countries, you can't have two trademarks in the same application. So you have to choose one, if you will, or they would have to be separate trademark applications. So what you would probably have to do is look at the revocation rules in that country, because if you register it, if you register one version, then in 5 years' time or whatever the revocation period is, if you haven't used it like that, someone could potentially come and cancel it. So it's always good to take that local advice again for that particular territory. But what I would just say to you, the easy answer for that is file a UK trademark, do it, put two trademarks in the same application, do your stacked version, do your long version, and then you get 6 months protection all around the world for both versions. And then before the get them registered in the UK, and then before the 6 month period expires, then look at your budget. And if you've got to file the trademark in the US, if you can only afford one, then just choose which one to file. Ask your US attorney or your UK attorney, to ask his US friend how to do this sort of stuff. But definitely get advice on that. And then I guess the next natural question is in terms of color. Do you register it? Some because a lot of companies they keep the same logo, but sometimes they change the color for whatever reason, friends or you know the new CEO just doesn't like the old color and he doesn't like red, he wants it in blue.
Yeah, that's a
So
nightmare. I've had that.
so when it's color, sometimes what a lot of people do is, again, in the UK, you can file two versions of the trademark in the same application. So maybe file it in the color that you actually use in commerce. And then I guess as a backup, maybe file it in grayscale. A lot of people file it in grayscale and it kind of, depending on what country you're claiming priority into, but it kind of does protect in a lot of places every single color scheme if you file it in grayscale. So but then again, it all boils down to taking that advice, just because
That's
it's all
interesting because I was under the impression that it was if you had it in black, it that covered everything. But you're saying it's grayscale is what would cover it being in
yeah.
sort of any
In
other
most
color. Because I think
territories,
my Pixels Ink one, because we're in the UK, I was able to get the red version and the black version in the
yeah,
same
yeah,
application,
sometimes,
and also the stacked version, and well, not the stacked version, but with the PI and without the
yeah,
the PI, and then the PI on its own was was a separate, and that was the one that got opposed. I wish I'd never done that, but it's proven is in the end a couple of years later it's proven useful for this live stream. So thanks for that question, Henry. So what I'm going to do is I'm going to quickly I'll just bring up your social channel info. I've got your website address, Twitter and Instagram all on the screen now, so everyone can see where you're at online. But let's just have I'm just going to have a quick scan, so just bear with me, Oliver, whilst I go through this. I did see that Kaz asked a question. Oh, yeah. Kaz is cracking some jokes I can see in here. But he did ask one which is, is fairly relevant and topical right now. Where do things stand? I'm probably what I'm going to ask is, where do things stand with AI generated logos and kind of, copyright and trademark? Because we know that, there's a lot of information that they've been trained on using existing content, but what they produce is slightly different. And I just want to quickly give my sort of feeling on that, and it's I suppose it's similar to me going and looking at existing logos and going, oh, that's quite nice, and pulling bits and creating something, not as a derivative, but I'm definitely using knowledge of stuff that I have. But I suppose AI is slightly different in that, well, I don't know exactly how it works, but there's a lot of, I know there's things going through courts right now, and maybe you need to wait on the results of that as well before you can start to apply trademark law to these things. But a lot of people are saying, how can you possibly copyright or trademark these things? Because it's just basically taking from other people. You can say, I could say, create me a logo in the design style of Kaz Kusumano, and I want it to, give a similar vibe to Nike. So you're kind of pulling in a specific designer style. You're wanting it to be in a similar kind of vein to that. Is there anything that kind of you've kind of been talking about with your team or with other attorneys about where this could potentially go?
I guess I guess the big question is are you infringing someone's earlier right? So if I talk to my computer and say, look, can you spit me out a logo with all of these features in there, and I get that within 2 seconds or however it is, and that it depends what kind of intellectual property right you're going to be infringing. So if I file a trademark application for that logo and it's similar to someone else's logo, then and it's and it's for identical or similar goods and services, or let's just say that that person has a reputation, and we go through that unfair advantage and tarnishment path basically, then it doesn't matter where I got that inspiration from. If the marks are similar, then you're bang to rights. If the issue falls squarely within one of those grounds, the dilution ground or the confusion ground or whatever it is. But I think the difficult bit is the copyright infringement issue, because obviously the test for copyright is whether you've used the whole or a substantial part of somebody else's work in order to get where you are. And who knows what happens behind the scenes when you talk to that computer. What does it do? So
that's what I thought. I thought the trademarking, I thought the trademarking would still just have the same thing that it does now. Is it, is it the confusion? Is it similar? Is it dissimilar? That's still going to be the same. So it's probably more the copyright side that's the gray area right now. It's like,
definitely.
Some people are saying it's fair use, and fair use can be stretched so far on things. You see it a lot on YouTube. People, whether it's playing music videos or parts of movies and stuff, and it's like, well, at what point are you past fair use? Just because you're kind of watching it and nodding along is not changing the sort of the content in a constructive way that you're, what's the word I'm trying to think? It's not reforming, but basically you're changing sort of the nature of the content, so it's something new. So I could probably have a film on and I could be deconstructing the film, like the camera angles, and discussing that. So you're actually using it as a teaching thing, so you can kind of get away with it that way. But that's the thing with the AI stuff, is that, how much of a similarity is it between, especially if you're an artist who has a very unique style and you've spent years to nurture that style, and then you can just say to AI, create me a logo in that style, or create me a painting of this person in their style. How much can you copyright your style? Where's the, you've not given permission for the AI to scrape your entire website of all your artwork so that it can learn your style. You've not given it that permission. So that's, so I think in terms of what this call's about today, which is mostly trademarking, it would be a case of, if you got an AI logo and it's spat out in 5 minutes, you would still have to go through all of the copyright to the side. And like I think you said, if if the software is giving you the copyright ownership once you've got it, because that's the thing as well, do you actually have the copyright to take it to trademark? If you do, then it's still going to have to follow all the same rules of a logo I designed, So I think, because obviously, designers and a lot of other trades there's a little bit of, oh my God, the robots are taking over, I don't have a job anymore. And there's other who are being more pragmatic about it and seeing it as a tool and a way to kind of quickly generate ideas that you can then take and hone into your own thing. So I suppose, and that's an entirely different live stream for me to do. And I'll maybe get Kaz onto that one and we could have a proper discussion about it. But let's just see here. So Peter's just saying, happy to answer any questions. The last question was the AI one. And like I say, Oliver, everyone's got all the links and stuff that where they can find you online. I know, do you want to quickly talk about, because I know that you've got, you're going to be creating some content and stuff of your own. I know that you were kind of mentioning, to me the other day that you're going to have a YouTube channel and, your podcasts and stuff like that. So if you want to kind of just have a very quick chat about what because we've talked about this as well, and you mentioned this isn't about getting people to use Trademark Wizards. This is the same as my channel. This is about educating people so that they're more informed, so that they can have a better kind of success rate with what it is they're trying to achieve. So I think if you're going to be launching some stuff, I'd love for you to kind of tell people what that's going to be so they can follow you and
Thank you. I think what we're trying to do is launch a kind of podcasty interview series where clients or people that have used our services come on, and I kind of just ask them about some horror stories, basically, if you will, about what happened during the trademarking process. And everyone's got their own different horror story. Well, the people that I choose to come on anyway. So if anything, it's not really an advert for us, because they've asked us to file an application, and it's all gone belly up. But it's all about what happened, why it happened, how it's been dealt with, etc., etc. And I think a lot of people can learn from that, because trademarking, the whole process, it can just be a complete gold mine. I'd say a complete sort of minefield. So it's good, because we've had clients that have had rejections of their trademark being descriptive, generic, non-distinctive, or other, clients have had their trademarks being opposed for being confused with someone else's trademark. Other clients have been sued for trademarking infringement or passing off, and it's interesting to understand what happened and hearing it from their point of view, because especially from the initial shock of receiving these challenges, and sometimes it could be the same type of challenge, but you're in a different stage of your business. If you have not launched your brand yet and you're about to launch your brand, but someone challenges you, you might just change your name, because it's relatively simple. Design a new logo, change your name. But if you're 2 years in and you decide to file a trademark and you jump on someone's radar, they attack you and they tell you to stop using the name, then we have a different problem, my friend. And it's good for these clients just to have a voice. Then some of them get
definitely don't follow my example of waiting sort of 15 years before you decide to get the trademark. And it was about 15 years I'd been trading as Pixels Inc. And one of the things was, it's like you said, it's like, depends on who you're doing business with. And I was just very local as a designer, very local, within my city. But then with my YouTube channel and stuff, it opened up visibility of me to clients in, UK wide, and then, globally. And it's just these things that you start to think about your business in a very different way and what could potentially happen. So I think what you're suggesting there about, almost sort of like client case studies of, here's what could go wrong, but here's how you prevent that. And that's a really good way of doing it. It's not teaching through fear, but it's just sort of like, this is what could go wrong. And so, go away and make sure that you've got all these things in place, or make sure you're speaking to the right people. And I do that in sort of my case studies as well, rather than just say, hey, here's a job that we finished, here's the end result. I talk about the process and, we hit a snag here, but how did we solve that? Okay, it wasn't a great time, but we got past it. And I think from Trademark Wizard's point of view, it shows anyone looking in that you are problem solvers, that you can deal with these things. And so, that is sort of like a salesy thing for me to say for Trademark Wizards, but it's also the same for me. If people can see that I'm a problem solver, then that goes a long way. It's not everything goes perfect all the time. And I think anyone that doesn't acknowledge that things can go wrong is doing a disservice to any potential customer base that they have, because things can go wrong and you need to be aware of it. And I'd much rather people be honest with me and say, this is what could happen, and here's what we'll do if it does. Don't panic, and like you say, when I got the letter through yourselves from the lawyers, it was like, a bit of an eek moment for me, but then it was like, no, don't worry about it, we'll get this sorted. But so I think we've been on for so we've been on for a while. We've been on for an hour and 40. I'm going to sort of end the call and say thank you so much for coming on. I know you said you could kind of talk about this for forever. I know that I could talk about these things as well. It's different for the people on the live stream. They're here, but anyone who's watched this through, thank you so much. I hope you've learned a lot from Oliver's knowledge. I really appreciate it. I've got the bug back for doing live streams. It's been a little while. I'll get back into YouTube and doing stuff again. And you never know, you might see my face on some of Trademark Wizards podcasts or whatever, if I get invited on as one of those horror stories that we talked about, and do that. So so thank you very much, Oliver. Thanks for coming, and
thank you for having me.
We'll see you later on. All right.
Take care, man.
Bye for now. Mate. Cheers. Bye. Okay, folks. Thank you so much for coming along. Thanks for taking part in the Q&A on there. As you can see, Peter was in the live chat from Trademark Wizards. They're a great bunch of people, and they're always open to you kind of giving them a shout out in terms of, if you've got any questions, you should, definitely check out their socials and stuff and interact with them there. They're really, really helpful people. I definitely got more knowledge today. There was a lot of assumptions I had, and Oliver's cleared those up, and I'll definitely be changing the way that I discuss trademarking and stuff with my clients based on what he said. Again, there were some technical issues. I'm hoping the audio wasn't too bad for you all, and I will look into that. And the last thing that I really want to say is that, if you haven't already, you're more than welcome to join my Discord community, the Rock Your Brand Discord community. I think we've got about 150 members in there now, where we just talk about, graphic design, branding. We've got a little book club going as well. So we choose a book every month to sort of enhance our knowledge around other areas of, not just design, but, business as well, so that we can all be better designers and better business owners, so that we can all make more money and get more clients. Feel free to jump in there. It's it's no fees or anything. It's a free community to join. So please do. Thank you so much for joining me, and until I see you next time, stay creative, folks. Bye for now.